Hello and welcome to the criminal section of the People's Law School. My colleagues and I will be discussing criminal law issues that we hope will be of interest to you. And we'll start by introducing everybody, starting on my across from me.
Oh, hi, my name is Will Kautz. I practice law with the law firm of Edwards, Bryan, and Kautz. While my law firm handles injury and accident as well as criminal cases, my practice is basically limited to criminal defense.
Hello, I'm Emily Roark, and I practice with Bryant, Shannon, and Roark. And just like Will, we do personal injury, domestic law, and I basically do all criminal defense.
And I'm last, Len Ogden. I'm a lawyer here in Paducah, and I have an office downtown, and my practice consists primarily of trial work in the federal and state courts. I do personal injury litigation, criminal defense, and a little bit of civil rights for the plaintiff.
And I'm Carolyn Keeley, and I'm a solo practitioner. I've done criminal law practice for about 16 years here, and my practice now consists about 50% of criminal defense work. We wanted to discuss criminal law topics that would be interesting to the folks that were watching, not something that is too technical for everybody to be interested in. So we thought we would discuss, everybody watches television, and I have found that everybody gets a lot of their criminal law knowledge from the TV shows they watch. So we thought we would discuss some of the issues that we see frequently on these television shows and try and discuss which things are fact and which things are fiction. And one of the biggest hits, I guess, recently and in the news has been these CSI, which is criminal science investigation or criminal
crime scene
investigation. I'm sorry, that's how much I know. So we thought we'd talk about the forensic evidence and first of all, and discuss what actually happens. Does this stuff really happen in at least our local jurisdiction? Does anybody have, or have they ever had cases where the one big case I had was a lot of forensic stuff that was done. It was a murder case. They did all this forensic stuff, and they got not one piece of forensic evidence out of it. And I'm wondering if you all have had cases where forensic evidence was a big factor. Anybody? Hello.
Well, I'll volunteer. I haven't had a lot of those. I think that's way overplayed on those shows. It would be wonderful. But it all comes down in most instances to how serious the case is, that is the nature of the charge, and also how much money is available.
What does that mean, how much money is available?
Well, from the defense side, sometimes there's not so much money available to take a look at forensic evidence, but from the prosecution side, there's usually a lot more. Now, the case I had primarily turned on, or at least we thought it was going to turn on whether or not there was gunshot residue on a jacket. And we had remember we had the jacket sent off to a fellow that had been the former head of the crime lab in West Virginia, and he was a gunshot residue expert. And the Kentucky State Crime Lab wanted to examine it, but they had a process that they were going to use that was not as sophisticated as ours, and we had the money in that case.
So you did actually have forensic evidence in this case?
Well, we hoped we did, and the whole deal was to take a look at this jacket and see if there was actually gunshot residue on it. And the State Crime Lab's testing would have destroyed that evidence. In other words, it couldn't have been then tested by us if tested by them first. Fortunately, after some litigation and almost getting held in contempt of court and some things like that, I got the jacket to this fella, and he used an electron microscope. And I'll never forget, he called me up at 6 o'clock at night, and he said no hits, which meant he found no gunshot residue. And I said, look an hour longer. And he went back and he called me up about 6:45, and he found a couple of hits. And ended up, though, that the jury totally disregarded the evidence, and it made no difference in the case. I think it should have.
What about, I mean, in these shows, you see, every time there's a crime scene, it's like call in, the lab people or whatever they call them, and all these people come in, and in books, the same thing. They all come in and they run the scene at just about every serious crime. They do that on TV. But amongst the four of us, we've had literally thousands and thousands of criminal cases. I found that to be a rare happening.
Forensic evidence is really rarely involved in cases I've either prosecuted or defended. I think fingerprints.
Right.
The public has an idea based on TV that fingerprint evidence is common, if not almost always existent, in criminal cases. And I've got to estimate that I've either defended or prosecuted 10,000 cases, and there's probably 10 where fingerprint evidence was introduced. Generally speaking, there are no fingerprints left at the scene of the crime, or at least none that can be, or none that are good enough for comparison purposes.
Well, is that why it's not used? Because there are none, or do they actually ever look for fingerprint evidence?
Well, I think too, what I've learned recently, just in the last probably 6 months to a year, Will and I had co-defense in a case, and we found out that unless you get an order really quickly, I mean probably in the first couple weeks, that you're not going to get those fingerprints preserved, because you've got to get them sent off to APHIS, and unless that happens, the evidence gets destroyed. It's not preserved correctly. And I don't think generally, like in a normal drug case where your client's saying, the drugs weren't mine, I never touched the baggies. A lot of times you'll get in a client like that. And unless you get that order entered extremely fast, then it's not going to get preserved properly for you to get the fingerprints. And it's not normally the course of action for the police to send off to have those fingerprints preserved. So I don't think it's normally done in a case like you see on TV, that they immediately take the evidence in and have it tested for fingerprints. I don't think that's the general course of how things are done.
We get the impression that DNA evidence is very often a factor in criminal cases, and in my experience it's almost never a factor. I guess it makes good TV, but the reality is, and it's kind of the scary reality, is that more often than not people go to prison for years, or maybe a life sentence, or maybe even a death penalty based on that's the guy that did it.
Mm-hmm.
And the reason, as we all know, eyewitness identification evidence is probably the weakest form of evidence, but it's probably the strongest in the eyes of a jury.
Mm-hmm.
Why is that, you think?
Well, for one thing, what a jury can't do is it can't be there and use the same eyes as the witness, have the same obstacles, the same weather, the same distractions. But for some reason or other, the jury, the trial jury tends not to understand that, and so they think if a person is standing there and they're within 15 feet, even though it's dark or there's just moderate light, that automatically they're going to be able to say, yes, that's the person, and be able to identify them subsequently. And it's just not so. One other thing I'd like to say, though, about the DNA, if I could, I've been seeing it used more and more. And recently I had a client, a young man, and he was accused by a young lady of having raped her. And we decided that we weren't going to give a sample of his blood, or in other words his DNA, to be tested, but we figured there'd be a court order for it. And there was. And as I knew it would happen, because I believe the young man, came back negative, and he was excluded as being the person that raped this lady, young lady. And I think the police finally decided that she had made up a story kind of protect herself from her parents' angry manner toward her, because they thought she was being around people that she shouldn't, and she made the story up. So that was a good way that it helped exclude, and so I think it's being used more.
Well, another thing on this DNA stuff, they get the results back in, 3 hours. And all this
On television.
Yeah, on television. On television, and my experience is it's an interminable wait to get DNA evidence back. It takes. Where does all this evidence go? If, for example, there was forensic evidence taken for testing at a crime scene or DNA. We don't have a lab here, to my knowledge, do we?
No.
What happens to that evidence?
So it goes to, there's lab in Madisonville, there's lab in Frankfurt,
And Louisville.
Louisville.
And or it goes to an FBI lab. The reality is, more often than not, it may ride around in the back of a police cruiser for a day or two. It then probably finds its way into an evidence locker, and it may be several months later that it finds its way, through the mail usually, to some either state or federal crime lab.
And a lot of times when you're at an initial hearing, initial preliminary hearing, you'll ask an officer, where is the evidence? And they'll say, it's at the Paducah Police Department. Like Will said, I think it sits there for a long time before it's sent anywhere.
I've had a problem with arson cases because I don't get into the case for maybe a week after this fire, and and nobody has preserved the evidence at all to do any kind of reconstruction of the fire. And nobody has, or sometimes the debris has already been cleared away by the time you get there. So that is also a problem with preservation of evidence.
And obviously, from a criminal defense perspective, we're often not retained until weeks, if not months, after the fact. And if the state hasn't done a good job preserving the evidence, then it's far too late for us to worry about it.
Do anything.
Biggest mistake, you're right, that the public makes, and that's because the public deems that the system will automatically be purely fair to the defense, is that the defense lawyer is not retained early enough. And it's a shame, because sometimes if you can get in there early enough, you know, you can do some things that are really helpful. And I see, for instance, a lot of preliminary hearings waived, and we probably don't want to get into that in great detail in this segment, but that's where there's a determination whether or not to refer a case on to the grand jury, and lawyers will just say, oh, my client waives it, and when you can get a lot of good information out of the police officer at a fairly early stage through that preliminary hearing. Now, of course, the district judges don't let us go into great detail on those preliminary hearings like they do in California. You'll see preliminary hearings for movie stars that are in trouble going for 3 or 4 hours or 3 or 4 days sometimes, and we're lucky if we get 15 or 20 minutes to
Or
ask
3 or
questions.
4 minutes.
Yeah.
Really. And I've never understood why everybody, in the interest of justice, wouldn't want to know. I mean, I don't understand why the prosecution doesn't want to hear evidence. I mean, it doesn't make any sense to me. I know Perry Mason, he apparently won all of his cases at the preliminary hearings with, you know, tons of witnesses, and of course then there was always a confession in the midst of that. And while we've mentioned preliminary hearings, assuming that you have one, and I'm like you, I always have one unless somebody gives me something to not. What happens if you won a preliminary hearing? What does that get you?
It can get you a dismissal. It will get you a dismissal at that time. That dismissal can remain permanent unless the prosecutor elects to present the case to the grand jury. I think that if a district judge fails to find probable cause, it gives the prosecutor at least food for thought as to whether he should further pursue the case, unless, of course, they find additional proof. Generally, the probable cause standard is so low that if a district judge has trouble seeing it, then certainly a jury at the circuit court level is going to have a hard time seeing guilt beyond a reasonable doubt.
But legally, that does not prohibit a case from being taken to the grand jury anyway.
And we have, as you know, a statute in Kentucky, actually a criminal rule, that requires a case to be presented if the defendant is in jail, requires that preliminary hearing occur within 10 days of his first court appearance. There are times when witnesses are not subpoenaed or witnesses fail to appear. That would require the judge to discharge the defendant. It's certainly, under those circumstances, I would expect the case to be walked directly in front of the grand jury once the state gets their ducks in a row.
And of course, what we're talking about here when we're talking about probable cause is we're talking about the standard of proof that's required in order for a district judge to make a decision to refer a case for consideration for indictment by a state grand jury in the particular county that is involved. And specifically, if I was to go over and handle a preliminary hearing, or any of us were, and we got a finding of no probable cause to believe that the defendant committed the offense with which he or she was then charged, then that would result in a discharge of the bond. In other words, if the person had put up $10,000 cash bail, then my understanding of the rules is that that would be freed up and the clerk would have to return that money that was deposited for pretrial release. And like Will said, it's not a dismissal that results in you never being able to bring the charge up again. And the reason for that simply is that you don't have jeopardy attached, the old double jeopardy that we talk about, because there has not been a trial. There has only been a preliminary hearing.
Well, and bonds is another thing that you see on television, on these TV shows. You have a prosecutor come in and a defense lawyer come in front of a judge, and the prosecutor always says, "We're asking for remand." I have no idea what that means. And
That means you go to jail.
You go to
Stay
jail.
there, yeah.
You go to jail. And the defense attorney makes his argument for the setting of bond. That's not what happens in this jurisdiction, is it?
Usually, once you're arrested, a pretrial officer will meet with the individual that's been arrested and set a bond, usually that night or within a few hours, and then you'll go before the judge the next day. But then usually you can have an attorney there when you go before the judge that next day. But you usually get a bond without ever even seeing a judge.
My experience has been that, especially on felony cases, that but misdemeanors too, that a pretrial officer will recommend a bond, but that more often than not, that is not the bond that gets set. That it gets set much higher than that, and in felony cases especially. You've been prosecuted, as I have, and brought the grand jury out with the indictments. What is that? Tell us what that procedure is about.
Well, of course, the return of an indictment, I think the public probably would be interested in the steps in the process. And usually a person is arrested either by a police officer who has what he believes is probable cause, or somebody may come to the county attorney's office and take a criminal complaint. At any rate, most felony cases would begin in district court. The district court judge would have to have a preliminary hearing, as Mr. Ogden said, probable cause hearing. That happens in fairly short order, within 10 to 20 days, depending on whether the defendant is in jail. If the judge finds probable cause, he refers the case to a grand jury. A grand jury is not a trial jury. A grand jury is 12 people who sit around in a small room with the prosecutor, usually hear from the police officer who has investigated the case, and they also make a probable cause determination. If they return an indictment, in other words, if they found probable cause, then the case is in circuit court. And as everyone here knows, circuit court is the case of jurisdiction in felony cases, final jurisdiction. On the question of bond, I can't tell you how many clients that we've all had that find themselves accused of a crime, presumed not guilty, legally presumed not guilty of a crime, but unable to post the $50,000 cash bond that the district judge, for whatever reason, believed to be appropriate. And it's kind of like, I thought I was presumed not guilty. And it's kind of scary, because as we all know, all it takes to prefer a criminal charge is somebody to go to the county attorney's office and tell either the truth or a lie under oath and get a criminal complaint, and any of us can end up in jail that easily.
Absolutely.
And all of those constitutional protections that we all enjoy and benefit from, in my experience, don't really apply until the day of trial, which can be a year after the fact of the charge.
Oh, absolutely. And if you're having a hearing or a discussion in front of the judge concerning bond, what I always hear is, well, but it's a serious charge.
Right.
You know, we're going to keep the bond high because the accusation is serious. And to me that seems almost incomprehensible, that seems to be the primary criteria after criminal record on how high the bond is set, with no consideration at all to the fact that this person has not been tried and convicted of anything at this
But now,
point.
since we don't have a prosecutor here, let me take, and I never want to be a prosecutor when I grow up, but let me take the...
Which will never happen anyway.
which will never happen. Anyway, the growing up. But anyway, let me take the prosecutor's side here. If we had a prosecutor, I think they could fairly argue, well, but, you know, a judge sets a bond either after an indictment is returned or after an arrest by a police officer, just basically on a felony on probable cause, and that is too high. The rules of criminal procedure allow for us as defense lawyers to come in by written motion and to apply to the court for a modification of the conditions of pretrial release. In other words, we can move for a bond reduction, and whether we get it or not is another thing, but the first time at least we're entitled to a hearing on that before the court. So there is that protection built into the system, even though we do have as defense lawyers a lot of fair complaints about the bail system.
Well, and the other point that I really wanted to make is that when the indictment is returned, and the defendant may or may not already be in the system when an indictment is returned. So there may be a bond set, or there may not have been a bond set yet because they had never been arrested. There may also be additional charges added to an indictment. And bond is set on each individual charge. My experience is the grand jury meets, the docket for the grand jury is not distributed. So we don't necessarily know when the grand jury is meeting on our particular client, nor does the client know that. When the grand jury returns indictments, the prosecutor's office calls the judge and says, "We're ready." The judge takes the bench. There's no announcement. The grand jury is brought in with a prosecutor. The judge is handed the indictments. He sets up there and reads them off. And if there is no bond previously set, he will say to the prosecutor, "What bond do you want?" And the prosecutor will say $10,000, $20,000. And I've never seen the judge not write in what the prosecutor said. There is nobody on the other side arguing the issue.
Or we don't even know to be there.
We don't know. We have no notice of it
But
whatsoever.
normally it's usually typed in on the indictment from...
If it already
Right.
exists. If it already exists. But I have had situations where I have come to court, the indictment was just handed down like right before the arraignment date. I've come to court to discover, and this taught me a lesson, to discover that they added a charge. So now there's he's on bond, he's already made his bond on charge number 1, but unbeknownst to me, they threw another charge in there and added another bond. And my client, they're looking to arrest my client because he hasn't made that bond, and I've got to run around. You can always get it fixed.
Oh, most always.
Most always. And I've also seen them up the bond, which they always say is inadvertent. So you may wind up with a surprise if you don't make, and I now make sure that I regularly check to see if my indictments have been
Well, you know,
entered.
the question of bond, and we probably need to get away from it, is probably subject to a whole complete session.
It is.
And because before I started practicing law, and perhaps even before Mr. Ogden, we had bail bondsmen in the state of Kentucky. And it wasn't...
No, I was there when they had the bail bond.
I was afraid you were.
Thank you, Mr. Kautz.
And it was not uncommon to have a $25,000 cash bond, and you had this bloodsucker called a bail bondsman you could turn to. Even people of moderate means could turn to and contract with this bail bondsman to post the bond. Kentucky, the legislature, I think, recognized that we didn't need these bloodsuckers in Kentucky, and we passed the Bail Reform Act. And it's my impression from studying the history of the Bail Reform Act that 10% bonds are supposed to be the norm.
That's absolutely my interpretation
But
as well.
for whatever reason, in McCracken County, historically, our judges either don't agree that that is the history of the Bail Reform Act or don't care. And as a result, you've got the kind of bonds we used to have before the Bail Reform Act, $25,000 full cash bonds, $50,000 full cash bonds, and no bloodsucker to turn to.
Right.
And so I think the entire purpose of the Bail Reform Act, at least in McCracken County, has been thwarted. I think basically speaking, you have a situation where people of low to moderate means rot in jail waiting for their day in court. And on that day, that trial date, now the state has to prove their guilt beyond a reasonable doubt. Now they're presumed innocent. Now all those constitutional protections rescue them if they're not guilty. But in the meantime, they rot in jail waiting for that day in court. I think the system needs to be fixed.
You're absolutely correct, and I think we would all agree with that. That's been one of my hot buttons, which is probably why I go off every time I hear the word bail bond. And then we hear the jail is full of people. And I'll guarantee you that a really large percentage of the people that are lodged in McCracken County Jail have not been convicted of anything. They simply can't make bonds.
And the jail needs to be full of people who are convicted of crimes, particularly violent crimes or repeat offenders.
Mm-hmm.
But the jail doesn't need to be full of people who are presumed not guilty.
It's so easy for lawyers to talk, isn't it?
Especially when there's no judge or prosecutor
Is that a
here
nice way to say
protect them,
criticize?
to argue their point.
No, I mean, no.
And
you're
it's their
absolutely-
job to protect the public.
Yes.
I'll tell you one of the biggest problems that I see right now in McCracken County, and maybe it's changed and I'm just not aware of it, but it's the use of technology. And technology is such a great thing if it's used correctly. But now we have what are called jail arraignments by television, or by television monitor, as everybody here knows. Mm-hmm. And I don't see that that's a great problem, but my difficulty is with it constitutionally, in that I don't know when they're going to have these. And
No, and they don't either.
And what I'm talking about for the ladies and gentlemen of the audience, television audience, is that somebody gets arrested on Wednesday night and they're going to come before a judge on Thursday, which is fine. And they may have bail set or they may not. And this is not a bail issue that I'm talking about. But anyway, a friend of the family or somebody in the family calls you as the lawyer and says, you know, I'd like you to go down and see so-and-so and I'd like you to represent them. Well, the defendant is brought into the jail, quote, courtroom, or like little auditorium, and there's a camera there, and the judge sits on the bench over at the courthouse across the street and advises the person of the nature of the charge and the bond and this, that, and the other. And normally there's no lawyer with that defendant, because the lawyer that has been requested to represent that defendant by the family doesn't know when this television court arraignment is going to occur. It could occur at 11 o'clock in the morning. It could occur at 1 o'clock
Well,
in the
and
afternoon.
that's because the
Unless they have changed that.
No,
recently.
they have
but
not
it's
changed
because
that.
the judges do it whenever they have time.
Right.
So
Yeah.
you know, how do you I can't think of the word, but anyway, how does that correlate with the notion of the Constitution that a person should be entitled to have a lawyer with them at every stage of the criminal proceeding? You know, there may be something there I'm not thinking about, but and I don't know that they're greatly prejudiced, but I think it would be nice to be able to say, okay, these television arraignments are going to be at 9 o'clock, 10 o'clock, 11 o'clock, 4 o'clock, whatever, so the lawyer knows when to be there.
Well, the biggest problem with that, and Emily, I know you know this too, because it happens on DUIs a lot, and I know you do, both of you do a lot of DUIs, is people tend to like plead guilty.
They're made an offer, because there's a county attorney in there now, and they're made an offer every single time. If it's a misdemeanor, they're made an offer.
Oh, I didn't know that.
Yes,
They just
they are
started
made.
that.
They just started that. There's a prosecutor there, a misdemeanor prosecutor. They're made an offer, and then I've found lately that if it's a felony, it's a good opportunity to attempt to get the bond reduced, because they will listen to a bond reduction, and pretrial's there. And I found pretrial to be extremely helpful.
Oh,
Kim
pretrial
Thornton
is
in her
helpful.
office, and also pretrial release program, which may be a whole nother program.
Explain so everybody will know what
Well,
pretrial
Pretrial-
services is.
Pretrial services is once you are arrested, you will meet with a pretrial release officer, and you give them your name, your address. It's the only time that an attorney tells you that it's okay to talk to somebody. It's not a police officer, it's a pretrial officer who will help you will get a bond. They will verify your information, find out how long you've lived in this area, if you have a job. They will look at your criminal record and basically find out if you're high, low, or medium as far as where you are in a rank for a bond. And then they call the judge and, as Carolyn was saying, recommend a bond, and then the judge will either accept that or not. And then there's also a pretrial release program now that I found really helpful, and that's kind of like a probation or parole before you're actually convicted. And you can meet with pretrial, you're drug tested, you may have to go in once or twice a week, and sometimes I think that the judges are only willing to do that on D felonies. A few times I've been able to do it on C, but it's before you're convicted, and you can get out on a lower bond, sometimes a surety bond, when you don't have a lot of money, like Will was saying, $25,000, $50,000, you may be able to make that $10,000 bond, but you have to meet with these pretrial officers. But pretrial is there, and they sometimes can help you with the judge and show them your client's record and possibly get a bond reduction at these arraignments that Len is talking about. But the problem is that they may happen at 9 o'clock, they may happen at 1 o'clock. The judge's office is really nice. I mean, sometimes I'll call them 4 or 5 times a day and say, when is it going to happen? I feel like I'm harassing them. But it does seem to be a problem of when they're going to happen, because your client wants you to be there. They have a right for you to be there. There's not a public defender there, so.
Well, it would be like a doctor at a hospital, and the doctor is waiting on the hospital to tell him what time he's going to operate. I mean, how can that work? If he's operating on somebody else at 9 o'clock, and they call and say, no, you got to operate on somebody else at 9 o'clock, he can't do both at the same time.
Right.
And that's what they're asking us to do here, and I think it violates the Sixth Amendment to the United States Constitution, and probably something else that I haven't thought of. But hopefully the judges, I know they're busy, but hopefully they'll rethink that and schedule it for a time certain on particular days, not only for the convenience of the lawyers, but constitutionally.
Well, while we're dealing with the process and we're talking about indictments, one of the other things that I see on television that happens a lot is a defense lawyer comes in right after the indictment and files this big motion to dismiss the indictment. And they go in front of the judge, and the judge says, oh, I'm dismissing this because you don't have enough evidence. What's your evidence, Mr. Prosecutor? And they dismiss them. Is that even a possibility, or is that purely fiction?
I think that as a matter of statute and case law, it's a possibility. As a matter of practicality, it won't happen. And really, probably shouldn't happen. Mr. Ogden is a constitutional scholar, and I know that he respects and believes in our Constitution, and one of the things the Constitution talks about is separation of powers. And it is the prosecutor's job to decide basically who's going to be charged with what, and it's the judge's job at some point to represent a different segment of the big three. And of course, I don't think a judge should really be in a position of saying whether or not an indictment should be dismissed, unless, of course, it was brought improperly. But it's up to a grand jury to decide whether or not the evidence is sufficient. And then it's up to a trial jury to decide whether or not there is guilt beyond a reasonable doubt. And I think if a judge sticks his nose into that issue, it's a problem. And they won't do it.
Well, and I know I have, and I'm sure all of you do. I have problems sometimes with clients that keep asking me why they're maintaining, I'm not guilty, I didn't do it, this is horrible, it's ruining my life, why don't they get rid of this charge? And it's very difficult sometimes to explain to clients that the prosecutor has the job of determining the charges and making the decision to bring a charge.
Now, of course, at trial,
It's a different story.
at trial, if the state hasn't put on at least enough evidence, a fair amount of evidence, then it's up to the trial judge to what we call direct the verdict and not even let the case get to the jury. But
And
until trial, I don't think the prosecutor, it's incumbent on the prosecutor until trial to produce his evidence.
You know what? One of the things I found out, and I feel so silly for not knowing this, but I was just reading through the rules of criminal procedure on grand juries last night, and you know, at the end of the indictment, before it's signed by the foreperson, or maybe it's below it anyway, over to the left-hand side.
Against the peace and dignity.
Well, I wasn't going to say that, but that's a good point. But there is a place where they type in the name of the witness or witnesses who
Yes.
testified before the grand jury. And if you don't, say they had 3 witnesses, of course, sometimes you don't know until, you know,
get the
tape. But anyway, if they had 3 witnesses and they only list 1, that won't get the indictment dismissed, but you can make a motion and get the names of the other 2 witnesses, and they must be supplied. And I've been practicing law for over 32 years, and you know, I don't think I knew that. I guess all of y'all did. But
Well,
and
I
I've
did-
never,
yeah, I did
I have
know
never
that's-
made a motion for additional grand jury witnesses not identified on the actual true bill indictment to be identified by the Commonwealth. But I'm going to do that sometime.
Well, and the thing of it is, of course, we have access to the grand jury tape, which
But now there are a number.
in effect gives us that information anyway, so.
There are a number of ways that you can get an indictment dismissed, but it just doesn't happen very often. One I can think of under the rules is that if they don't record in some way or other what goes on in the grand jury as far as the indictment goes, then you can move to dismiss. However, if it was because of a failure mechanically in the recording equipment, then you won't get the dismissal. Another one is, I suppose, if somehow you were able to find out, and I'm not sure it's very easy to do, but if you don't have 9 out of 12, you know, vote for an indictment. Let's say there's 7, and still they return the indictment. That's not enough. You got to have 9 out of 12.
Well, one of the things, and that the only one that would probably be most common that would come up with an attorney is that it fails to charge, it does not charge a crime. Failure to actually charge an offense in the indictment would be cause for it to dismiss.
I think between us, there's probably about close to 100 years worth of criminal defense experience.
all his.
Most of it is.
That just means I'm old.
And
That's right.
I can tell you what, I'd be surprised if anyone in this, any of the 4 of us have ever succeeded
No,
in
never.
a motion, a pretrial motion to dismiss an indictment.
No, I've had them amend it. You know, if there's something wrong and you bring it to their attention, they'll be happy to amend it.
You know, we've got a great system as far as that day in court.
It's a long
You know,
trail to
having
get there.
been there, you and I have both been prosecutors, having been there, it's not easy to convince 12 out of 12
No.
people beyond a reasonable doubt that it's raining, even if it's raining. You know, it should be
Hard.
easier.
I think it should be hard.
It should be hard to convict
Yeah.
somebody of a
Yes.
crime and deprive them of their freedom. That's what this country's all about. I just wished we had a way to make all of that happen quicker, especially since, at least in McCracken County, so many defendants are rotting in jail waiting for that day in court.
Well, and back on the subject of prosecutors and their charging authority, one of the things, I remember as a prosecutor, I went to one of those prosecutorial conferences, and Nothing, you know, I love prosecutors. I don't always.
No, you don't.
As people, okay, they're fine. As prosecutors, that's something else. It was so, I had been to all these criminal defense thing. I've been to a lot of criminal defense seminars, and I've been to one prosecutor seminar, and it was so very different. And most of the sessions that I went to at this one had to deal with what my liability would be. Could I get sued? And one of the things that's always stuck with me is the ability of a prosecutor to step outside the prosecutorial duties. And in so many of these TV shows, the prosecutors are working directly with police officers. They are instructing the investigators on how to investigate the crime. They are telling them whether they have probable cause or not. And I wanted to discuss that with you all, is what are the duties of a prosecutor? Do they really control the investigation? Do they work with cops like that? And what happens if they step over those bounds?
Well, under Kentucky law, prosecutors have a degree of immunity from civil suit, as long as they're performing their prosecutorial function. It's not a function of a prosecutor to investigate a case. That's a function of the law enforcement agency that's involved in the case. When the prosecutor steps over the line and becomes an investigator, I believe he loses his immunity from civil suit. And I think most of the training I received at those prosecutorial conferences was designed to cause prosecutors to keep in mind that that's their job, and it's somebody else's job to investigate crime. There are prosecutors locally in Western Kentucky who will go straight to the scene of the crime, and I think I'm thinking of at least one prosecutor in an adjoining county who's no longer a prosecutor, who I think would rather be an officer than a prosecutor. But that person I'm thinking about was way out on a limb as far as civil liability.
So when we read books about crime and see movies about crime, and the first thing that happens is the assistant DA shows up at the murder scene, that would not be fact.
I
Not
think
in my experience.
I think it's a pretty bifurcated system in McCracken County. I think the officer investigates it, writes up their citation, their case file, and turns it over to the Commonwealth Attorney's Office
You know,
here in this
and to
county.
take it one step further, Perry Mason and/or Matlock always went with their investigator to interview potentially hostile witnesses, and/or they did so themselves.
I absolutely don't do that, and somebody better explain why I don't.
And the reason that you don't and that we don't
Right.
is because if that witness tells us one thing off the record and then in trial says something else, now all of a sudden we've made ourselves witnesses. And so I think it's a TV misnomer, I guess you would say, that causes the public to believe that one of the things a defense lawyer does is investigate the case. That's not to say that we don't talk to friendly witnesses, witnesses that we believe won't turn and burn us, because most of our clients can't afford a private investigator to interview every potential witness. We've got a lot of financial limits. In a perfect world, I wouldn't even interview a friendly witness.
No, and for the audience to understand that, if I go over and I talk to witness John Smith over here, and John says, yeah, your client was right there with me all night, couldn't have shot the victim here, you know, and so I waltz into court and I say, I got this made, and I put this witness up that I've talked to, and that's all it does, talk to him, and they get up there and they say, no, he wasn't with me. What am I going to do? The only thing I can do is say, well, don't you remember talking to me on such and such day at such and such time, and didn't you tell me that he was with you and he couldn't have shot the victim? No, I didn't tell you that. I talked to you, but I told you I didn't know anything about this matter.
And if you have an investigator,
how am I going to prove that he's not telling
Right.
the truth? Now I've got a jury you know, saying, well, who do we believe here? Well, he's the defense lawyer. We're probably not going to believe him. But if I had had that recorded or had an investigator there that I could have called and countered it, or better still, had a written statement signed by the witness, then I could read that back and I could show that to the jury, and I could convince the jury that now this witness was changing his or her story. But I couldn't do it if all I did was interview him myself. Because am I going to get on the witness stand and testify? It's not going to work out very well.
Well, along the same lines with looking at what prosecutors do in real life, one of the other things that I see happen in a lot of shows is they'll have a trial, and of course the brilliant defense lawyer gets a confession from a witness.
Captain Kirk.
Yeah.
On Boston Legal.
Yes, absolutely. Gets a confession from a witness, and the trial is over, and the defendant, hugs his lawyer, and everybody goes home. What would be the real procedure if a witness should remarkably confess on the witness stand? Emily, what would happen? Would the trial be over?
I think it depends on the prosecutor. I recently had a case, it was a drug case, and the guy's girlfriend, of course, said that the drugs were his, and of course the Commonwealth Attorney's Office said, fine, the drugs are hers, but we'll just prosecute both of them. So, I mean, it's always a possibility that someone else can confess to the crime, and the Commonwealth Attorney's Office, prosecutor's office believes that both of them are guilty. They may go ahead and go forward with the jury trial against your client and then indict the other person for it too. I mean, there's no double jeopardy against that person.
Unless the prosecutor, in his mind, is convinced the witness is telling the truth, then he has an ethical obligation to back off, to dismiss the charge against the innocent party.
I think a lot of times on TV, though, the judge dismisses it, and I don't think that's what would happen in this case, in the real world, I guess.
So the prosecutor would still be in control of that charge?
I think so, unless, like Will was talking about earlier, you move for a directed verdict, where the judge could determine if there was enough evidence, and the judge could direct a verdict before it went to a jury.
And then that would be measured by that old Supreme, well, I guess not old, but anyway, Jackson case, was it Jackson v. Virginia?
I don't remember
Anyway,
names.
says that, whether or not a rational trier of fact could be convinced by the evidence beyond a reasonable doubt of guilt. That's a bad paraphrase, but that's essentially what it says. And so a judge would have to feel like that the proof was to that point that they couldn't be convinced in order to dismiss, or else he'd have to leave it with the prosecutor's decision. And I suppose that you could end up with two people convicted of the same offense, say for the same drug, and never really know who was guilty and who wasn't. Maybe they both were, or maybe only one was.
The reality is, though, I've had one case in 29 years of practice of law where any witness has confessed in the course of a trial, and I was quite surprised that happened.
Yeah, and this didn't happen in the course of a trial, what I'm talking about.
So I think that TV, no matter how good we may be at cross-examination, we're usually not good enough to cause the lying witness to come clean. Hopefully the jury sees through it, at least part of the time.
One of the other issues that comes into play a lot, I think, with I just have to mention this, okay, because we mentioned Boston Legal, because I love Boston Legal, but I swear to God, they come to work in the morning, there's a guy waiting that's got a murder trial in 15 minutes, and he says, sure, yeah, I'll represent you, and they all rush down to the courtroom to do a murder trial, like certainly within the hour.
And they always win.
And they always win, yeah. Is it that easy to get ready for a trial? I know there are judges who may think it is, okay, but what is the real prep time and lead time that it is required for a good lawyer to do a good job in getting ready for a serious trial?
Nobody wants to commit to that.
Nobody wants to commit to it.
Because then our clients are going to say, my goodness, you should have started 6 months ago.
And But
God,
I mean, for myself,
they finish their cases up and have what, a martini and
By lunch,
cigars
yeah.
on the veranda or balcony, and by 5 o'clock.
Yeah, and they never prep. They're never doing
Trials
prep work.
for trial attorneys are fun.
Yes.
What's not fun is the 6 months you spend getting ready for that trial. There are lawyers that I've known that are good enough to know very little about their case, very little about the state's case, to run into a courtroom cold and kick butt. I'm not that good.
Well, and I would disagree that there's any lawyer that can consistently do that as a defense lawyer. As a defense lawyer.
Yeah, it's easier as a prosecutor.
As a prosecutor,
Right.
yeah.
But we've known some lawyers. It's kind of a gift, and that can do that.
But a great lawyer once told me that it's all about the process. And if you work the process, you do your research, you do your investigation, you do your preparation, you do all those things that it takes 6 months to do, and it always increases your odds to be prepared. I mean, in whether it's anything that you do in life. So that's, and to lose a trial and then look back and say, if I'd have just given it one more week, if I'd have just worked a little bit harder.
And the downside, and you and I both know this, we've both been prosecutors, we've also both been directing attorneys at the public defender's office. The downside, at least in the years I was directing attorney, the average caseload was 2,000 clients per lawyer.
That's about right.
And we were given not only capital murder cases, but we were given theft cases and maybe misdemeanors. How much time did I have to devote to those misdemeanors or those low-grade felonies when I had 2,000 cases, some of which were capital murder or rape or kidnapping? The reality is that the time didn't allow for effective representation of counsel, and I think that perhaps the numbers have gotten better in the public defender system since we were there, but it's still pretty scary. I find most of the public defenders to be highly committed, highly energetic lawyers that don't have enough resources, particularly the resource of time, to do a good job. And it's for that reason I think that people that can afford private counsel are well advised to retain private counsel, having nothing to do with the level of skill or the level of commitment of that public defender, but having everything to do with the amount of resources, of time that public defender doesn't have to devote to your case.
I think that probably is true. The other thing that I wanted to discuss when I got off on Boston Legal.
Well, I brought it up because it was in your outline.
Well, no, I am the worst. Okay, I mean, I can easily spend 6 hours getting ready for a 3-hour hearing. I mean, easily. I mean, you've got papers, you've got exhibits, there's all this little technical stuff that you absolutely have to have organized, because there's nothing worse than to be in a courtroom and say, wait a minute, Your Honor, I'll find that in a minute. I mean, you really don't want to be disorganized. But one of the other things that I see a lot on television and movies, and there's whole genres of books just about the psychiatric aspects of criminal cases, and this is particularly true in homicide cases. I know Law and Order, several of those shows have resident psychiatrists that willy-nilly, they work for the prosecutor, and they just willy-nilly get to examine defendants. Is that, how does psychiatry play into the practice of criminal law?
Generally, we ask for our clients to be examined when they get examined, and then
I don't think I've ever had a prosecutor ask.
Not that I recall. And generally, we ask for them to be examined, and then I think Four Rivers is doing it here locally, or they go to right outside Louisville.
Luther Luckett.
Yeah.
Luther Luckett, yeah.
There was a time when Len and I started practicing law where you had basically 2 potential verdicts, 3, not guilty, guilty, or not guilty by reason of insanity. And so people that had significant psychiatric issues were very often exonerated. And I think the legislature didn't like that. and they came up with another option, guilty but mentally ill.
Which is no option.
Which is no option because you go to the same prison and you do the same time that you would have done were you straight up guilty. Since the legislature adopted GBMI, which was probably 20 to 22 years ago, Len, 25 years ago, I doubt that very many people have been found not guilty by reason of insanity. That being the case, I don't think many of us defend criminal cases based on insanity. You might use your client's mental state to create some mitigation to lessen the impact. But I think I'd be surprised if there were 10 not guilty by reason of insanity verdicts since they passed that legislation more than 20 years ago.
Well, the other, one of the other, we're getting very, very short of time, but I did want to touch just briefly, if we could, on, and it's something else that Alan Shore does, and he's my hero in Boston Legal, is jury nullification. That's what we know it as. But what he does, his client is guilty. He comes in and convinces the jury that he's a nice guy, the law's stupid, find him not guilty. Does that? I mean, I know it happens, but is it legal, strictly speaking, to have a jury just find somebody not guilty when they really are?
Absolutely, it's legal. You can't go behind the jury's verdict, and maybe I ought to go back and read the Code of Professional Responsibility again, but I've tried, I can remember one case I tried, an assault case, and by accident I won because the jury nullified the law, in other words, didn't follow it. And the case I recently tried, I essentially told them to do that.
That's what'll get you in trouble.
Although I didn't come
Okay.
right out and say it, I said, you don't want to convict this young lady of this offense under these circumstances. And I gave them a way out.
Yeah.
And that was how I used the defense of jury nullification of the law.
But it's really a bad word to say in front of a judge.
It is.
Great.
I think it can work the other way too.
Yeah.
I think juries can convict people because they don't like them,
Absolutely.
Right.
notwithstanding the fact that there's plenty of reasonable doubt.
Your
I think
client
that's
is
where-
the most important person in the
the courtroom,
case, in their
absolutely.
defense, and sometimes so important that you need to keep them off the stand because they'll convict themselves.
I did have one case one time where my client had to testify and he was horrible. And at closing, I said, look, my client is a jerk. You could see he's a jerk. He aggravated everybody he came in contact with. Nobody likes him, and that's why they charged him. And they found him not guilty. Because, sometimes
You used it to help, yeah.
And I got to
Yeah,
hand
it
it
is
to
to
you
help you.
because you went way out on a limb doing that, but it was the right thing.
Yeah, it was. We are running out of time. I don't know how we always run out of time so quickly. I hope everyone has enjoyed our discussion and maybe learned some differences between fact and fiction and what you see on TV and reading the books. The McCracken County Bar Association has sponsored this section of the People's Law School, and we thank you for tuning in.